Hi, I'm Shan Wu with a Undercolor of Law hot take on the Supreme Court's decision to hear, for the first time, a challenge to a ban on transition care for transgender minors. So this is going to be taking on the state of Tennessee's ban on providing different kinds of medical care for transgender minors. And the Biden administration is challenging that as being discriminatory and unconstitutional. Now, up until now, the High Court has steered clear of this issue. They've had lots of opportunities to weigh in on it. They've not chosen to hear the disputes about, like, which bathrooms can transgender children use in schools, the issues about who can play on whose sports team. All that they've sort of managed to avoid. Now, there are a bunch of different lower courts, federal courts, have reached different decisions about this because at this point, almost half the states in the country, imagine that, have laws addressing this. Over half of the states are banning this type of medical care. So why are they addressing it right now, and is it a good idea? Well, it can look like this is the classic kind of case that the Supreme Court is meant to take on, which is one of the reasons the court will grant certiorari is if there's a split in the federal circuits. So oftentimes the court wants to resolve a conflict with different federal courts coming up with different decisions. So that's certainly a reason why they would have taken the case, and a lot of experts had expected that's why they were going to take the case. But here's the thing. It's not really a organic sequence of events that's happened here. The entire hatred and discrimination that's directed at transgender rights has a long history, and it's been carefully cultivated in the conservative universe by all these decades of grooming and putting into the lower courts a bunch of Federalist Society anointed judges with the plan that ultimately, if you put in enough conservative judges in the lower courts, some of them are going to rise to the level of the Supreme Court. So, of course, today we have the ultra-conservative majority now on the court, and they've already demonstrated their power in reversing Roe versus Wade in the Dobbs decision. And we're at about the anniversary of that decision having occurred, where Roe was overturned. That's a half century worth of protection for women's reproductive rights got pushed aside by the new conservative majority. But it took a long time to get there. The real impact of the reversal of Roe is in the area of privacy rights, because it was really based on the idea that there is a constitutional right to privacy. So with that really being cast aside and put into doubt, it allows the court now, the High Court, to take on this question of transgender care in that prism, looking at it from the point of view of what would the constitutional basis be. That's what to watch for when it comes to the High Court next term, because the Biden administration is going to correctly pose this as a question of discrimination based on gender. Now, it's kind of a little bit of a twist, right? Because this is a question of gender dysphoria, where people want care for themselves to help them deal with what gender they really should be. But it's so tied up with gender discrimination that it makes perfect sense to argue it from that standpoint. And it's going to be a little bit of a mental gymnastic event for the High Court to manage how to avoid coming down correctly on the legal side of it, which is to say, of course, you can't single out people who want this type of medical care merely because it doesn't fall into a traditional notion of gender. That would be discrimination on its face, because you're discriminating against people based on a gender issue. But they're going to avoid taking it on that way, because what's really going on with the Supreme Court and this decades-long effort to get this conservative majority is it's really part of the religious rights efforts to return the country to some sort of, gauzy fantasy about an America where everybody looked the same, everybody loves the same, this non-existent place they want to bring us back to. Because that's the real agenda that's going on. They're going to have to hide that. And to hide that, you're going to see a lot of legal theories being put forth. There's going to be issues of originalism, and you'll possibly see a split between the more traditional originalists, the arrogance of a Clarence Thomas, who is going to argue that unless the word transgender appears in the Constitution, there's not going to be any basis for protecting those folks, to the more young Turks, as I call them, the Kavanaughs, the Amy Coney Barretts, and Neil Gorsuch, trying to parse this in a way that still furthers this conservative agenda, but does it in a way that may mask it more as a legal analytical discussion. There's going to be like a town hall of right-wing legal theories being kicked around when you see that decision eventually come out. And it probably is going to be a real maze of concurrences, dissents from the liberal justices as well. But the critical thing to remember is how all this is really looking to further this conservative agenda. And it's interesting to see which kinds of cases that this new powerful majority is comfortable taking on. Now, in the area of this privacy issue, the real extreme people like, Thomas and Alito may want to directly take on the right to privacy and just say, forget about it, doesn't exist. But more moderate conservatives like Chief Justice Roberts, they're going to want to hide that under some other kind of facade in their legal analysis. So notice what the court's always the most comfortable doing. They've avoided the sort of locker room question, which bathrooms can people use the same locker rooms? Maybe because it's a little bit distasteful to them. They like to talk about very highfalutin, highbrow questions of medical procedures. Now remember, ironically, Roe, at its heart, is approving a medical procedure. And the author of Roe all that time ago, Harry Blackmun, Justice Blackmun, was not a doctor, but he weighed in on this medical procedure, finding a constitutional basis to protect it. Over and over again, you see that this court feels very comfortable weighing in, second-guessing medical issues. Because if you think about the Dobbs opinion, what are they really doing? I mean, they're taking away this medical procedure that's been in place for a half century, and they're replacing it with the idea of, let it go back to the states to decide. We're not going to have a constitutional reason to keep this in place. What happens when it goes back to the states? Well, there's been a trend also over decades that many states, red states, are very powerfully against the idea of abortion rights. So you get this hodgepodge of rules in the different states, which you would think might also be okay for this issue. If the court is genuine in saying let the states decide these issues, they should also be perfectly fine with there being a crazy quilt pattern of some states say transgender care is okay, some say it's not. Just let it sit there. They didn't have to take this case to resolve it. But that's not what they're really doing. They're taking it to further this agenda. And it's also very intellectually disingenuous, or at least at odds with the conservative movement, because conservatives say, look, these are decisions for parents, right? You hear that all the time. You don't want to take away the decision of what parents decide they want their kids to learn about. That's why so many kids get pulled out. Conservative parents pull them out. They don't want their kids being educated about sexual issues in school because that's something that the parents want to own to make those decisions. Okay. Well, here, for the transgender minors, you would think that that should be a decision for the parents to make. They know their child, and if they think their child needs medical support, medical care for this, they should be free to do that. Why is the Supreme Court stepping in on that point? Well, they're stepping in because you're going to hear that some doctors are going to argue that it's questionable whether these types of care or treatments really help the child, number one. And number two, you may even hear some of them saying that it's a potentially dangerous or an unproven medical procedure. On that first point, whether it really helps the child, that runs squarely into the question of letting parents decide what's really helpful for their child. Why should the Supreme Court be weighing in on that? Second point, this is not some sort of wacko fringe medical theory going on. Obviously, it's been tested, used extensively, a whole sort of panoply of different kinds of treatments. It's not an issue of, we're going to weigh in here and decide that something that the FDA doesn't approve nonetheless is going to be used. That's not what the Supreme Court does. I mean, that's left to agencies, it's left to doctors, it's left to scientists, it's left to the medical profession. The idea that they feel free to step in and review this issue and basically decide, what's a proper medical procedure, what's a proper medical treatment, is completely out of step with what they're supposed to be doing. But I think we're going to see a lot more of that happening unless there's a real shift in the political power. And in addition to that, because that's just a matter of voting who gets the majority, there has to be a shift in the political will. If there's a new majority, that majority has to have the will to make changes and use that power. So that's it for now. Again, keep those comments and replies coming. It's really helpful to hear what it is you're interested in hearing us talk about. Talk to you soon.
Love this video? Make sure you stay up to date on the latest breaking news and all things Midas by signing up to the MeidasTouch newsletter at MeidasTouch.com/newsletter.